Hello, my name is Brant Hunt. Today is the 12th day of March, that is 2023. I'm going to be reading from a book called Woe Unto You Lawyers by Fred Rodell, R-O-D-E-L. He was a former professor at law at Yale University here in the United States. And my channel is Discerning What is True. Um, and I'm on YouTube, actually on Odyssey, and also on Facebook. So let's get into the meat of the book here, and let's share some good insights from Fred Wardell. The name of the chapter is No Tax on Max. Here's a quote from Charles Dickens. If the law supposes that, says Mr. Bumble, the law is an ass and an idiot. Okay, kind of sets it straight, doesn't he? In case anyone should suppose that the exalted acme of the lawyers art known as constitutional law cannot possibly be so unconvincing. Hold on just a second. Let me do something real quick before I forget. It's possibly so convincing, so inept, so silly as a quick summary of Supreme Court logic perhaps makes it sound. It might not be too bad an idea to take one of the court's cases about the Constitution and what it really means and give that case or opinion a thorough going over. The subject of this little experiment is a section will be a case known to the lawyers as Senior versus Braden. That is, it was decided by the Supreme Court in the spring of 1935. No, Senior versus Braden was not a course chosen at random. It is for a Supreme Court opinion. Mercifully short, it involves the court's favorite constitutional springboard, the good old due process clause of the 14th Amendment. It reveals the court as its most legalistic, its most spacious, its most unsubstantial, though for that purpose any one of the thousand cases might have served equally well. Furthermore, Senior versus Braden was not a unanimous decision. It was a 6-3 decision. But the existence of a dissent in any case involving its interpretation of the Constitution has been, for some time now, the rule rather than the exception, and the dissent, be it remembered, doesn't count anyway. The majority opinion is the law, that is, the gospel, so much so that even the dissenting judges must accept it, as with Senior versus Braden. They have accepted it when the case is used as a basis of legal argument in the future. In short, Senior versus Brayton is today an intricate and a respectable part of the law of the land as set forth by the top craftsmen of the profession. Here then interspersed with a almost literal translation of each paragraph into a non-legal language, and with a few pertinent or maybe impertinent comments, is the Supreme Court opinion in Senior versus Brayton, and hang on to your hats. January 1st, 1932. Tax Listing Day, Section 5328-1. The Ohio General Code provided that all investments, all intangible property of persons residing within the state should be subject to taxation. This is in 1932. This is going on during the Great Depression, folks. Okay. Section 5323 so defined investment as to include incorporate rights of a pecuniary nature from which income is or may be derived, including equitable interest in lands and rents and royalties divided into shares, evidenced by the transferable certificates. Section 5638 imposed upon productive investment a tax amounting to a 5% of the income yield, and Section 5389 defined income yield so as to include the aggravated income paid by the trustee to the holder. Now, who is the trustee in here, folks? Let's get to the point. It's your trust. This is going to, this is not what they say, but I want to explain something here, because they keep thinking we're the trustee when we're not the trustee. We never have been the trustee. You see, we're not the debtors. You see, we are the creditors of this country. We are the fucking creditors. They are not. They never have been. But what they've done is to circumcise law here. You see, they with the public unaware, going through what I call probably the worst time at that time in history, when the country is basically very few people have jobs. people don't have much money, you see, and many people sometimes here in the South were working just for food. These people are criminals. I mean with a capital Criminals. These people are despicable. They did it when the people were struggling. They did it. They don't care about you, folks. When are you going to fucking wake up? They don't. They see themselves superior to you. So it is your trust, you see, and you are the beneficiary, not them. But they've completely turned it all around. So let's continue on. Under Ohio law, anyone who lived in Ohio owned stocks or bonds or such had to pay a tax of 5% on the income from them, even if he got the income through a trustee or keeper of the property for himself. Appellate owned transferable certificates showing that he was beneficiary under 7 separate declarations of trust entitled to stated portions of rent derived from specific parcels of land, some within Ohio, some without. On account of these beneficial interests, he received $2,000, 2.231, that is $2,231.29 during 1931. The man who brought this case up to the Supreme Court, and by way of introduction, though no courtesy of the court, meet Max Senior, had some pieces of paper showing he had a stake in 7 plots of land in Ohio and elsewhere. His stake was worth over $2,000 to him in 1 year. Now, it's none of their damn business what you have, folks. That's another key. The tax offices of Hamilton County, where appellate reside, threatened to assess these beneficial interests and then to collect the tax of 5% on the income therefrom. To prevent this, he instituted a suit in the Common Pleas Court. The petition asked that Section 5323 General Code be declared unconstitutional and that appellates be restrained from taking the threatening action. The trial court granted the relief as prey. The Court of Appeals reversed, and the actions was approved by the Supreme Court. The local tax collector, one of whom incidentally was named Braden, Braden, tried to get $100 out of Max. He, through his lawyer, naturally claimed the Constitution protected his $100-odd, took the case to court, and got licked so far. With commendable frankness, counsel admit that under the 14th Amendment, the state has no power to tax land or interest in land situated beyond its borders, nor has it power to tax land or interest in land situated within the state or any other manner than by uniform rule according to value. Consequently, they say if the property of appellate, which the appellate seeks to tax in this case, is land or interest in land situated within or without the state, their action is unconstitutional and should be permanently enjoined. The lawyers for the state of Ohio say with a sort of double dare in their tone that if the court should be any chance called this a tax on land, then they give up. They know that the court won't let Ohio tax land in, say, West Virginia, that any such attempt would be labeled a taking of property without due process of law in violation of the 14th Amendment. And still with a double dare, they're willing to throw up the whole case and admit that Ohio can't even tax Ohio land in this way. If this is a tax on land, notice instantly that here, in a rather casual phrase reference to some of the lawyers' arguments, is the only mention of the 14th Amendment in the whole opinion. The validity of the tax under the federal Constitution is challenged. Accordingly, we must ascertain for ourselves upon what it was laid. Our concern is with realities, not nomenclatures. Moffitt, Moffitt versus Kelly, 218 U.S. 400, 404, 405. McCollin County versus Massachusetts, 279 U.S. 6230, 625, 626. Educational Films Corporation versus Ward, 282 U.S. 379, 387, Lawrence versus State Tax Commission, 286 U.S. 276, 280. If the thing here sought to be subject to taxation is really an interest in land, then by concession, the proposed tax is not permissible. the suggestion that the record discloses no federal question is without merit. This is a serious matter because somebody brought up the Constitution. Therefore, we, the Supreme Court, are going to have to make up our own minds whether this is a tax on land or not. As we said at least 4 times before, and if you don't believe us, here's where to look it up. You can't fool us with words. We want to know what really is going on. But if we decide this is a tax on land, then we don't have to bother to make up our own minds whether the Constitution forbids it. We're perfectly willing to take the lawyer's word on that little matter. And incidentally, the idea that this might not be any business of ours at all is beneath serious consideration. This is all in brackets here. 3 of the parcels of land is outside Ohio, 4 within. They were severally conveyed to trustees. The declaration of trust relative to the Clark Randolph building site in Chicago is typical of those in respect of land beyond Ohio. The one covering East 6th Street property, that is in Cleveland, is typical of those where the land lies in Ohio, except Lincoln Inn Court, that is in Cincinnati. Each parcel has been assessed for customary taxes in the name of a legal owner or lessee according to local law, without deductions or diminutions because of any interest claimed by appellate and other similar situations. Now, to go back to Max Sr. and his profits, each piece of land he had at stake is in was being kept and managed for all the people who had stakes in it by another fellow. Also, each piece of land had been soaked for the regular local property tax, regardless of the fact that a lot of people were making money out of it. The trust certificate severally declares that Max Sr. had purchased and paid for and is the owner of the undivided 340-1275 interest in the Lincoln Inn Court property, that he is registered on the books of the trustee as the owner of 5-3250 of the equity ownership and beneficial interest in the Clark Randolph building site in Chicago, that he is the owner of 6/1050 of the equity ownership and beneficial interest in the East 6th Street property, that is in Cleveland. And each declaration, the trustee undertakes to hold and manage the property for the use and benefit of all certificate owners, to collect and distribute among them the rents, and in case of sale, to make pro rata distribution of the proceeds. While certificates and declarations vary in some details, they represent beneficial interests which for present purposes are not substantially unlike. Each trustee holds only one piece of land and is free from control by the beneficiaries. So you see, they are not joined with it in management. See Heck, HECHT versus Mallard, MALLEY, 265 US 144, 147. Brackets. The legal language of the documents under which friend Max holds his stake in these plots of land all refer to him as the owner of something. He doesn't, however, own a little chunk of any of the plots in the sense that he could go and build a fence around it and sit there. He hasn't even anything to say about the way it's run. All he gets is his share of the profits when they come in. Our concern, remember, is with realities, not nomenclature. The state maintains that appellate interest is a species of intangible personal property consisting of a bundle of equitably chosen in action, because the provisions of the agreement and declarations of trust of record here have indelibly and unequivocally stamped that character upon it by giving it all the qualities thereof for purpose of management and control of the trust. At the time the trusts, that is, trust multiple, were created, the interests of all the beneficiaries consisted merely of a contingent of rights, etc., and such was the interest acquired by appellate when he became a party thereto. The rights of the beneficiary consisted merely of claims against the various trustees to the pro rata distribution of income during the continuance of the trust and to the pro rata distribution of the proceeds of a sale of the trust estates upon their termination. Brackets. Ohio, out to collect its tax, claims that since Max not only can't put a fence around any of the land in question, but it hasn't even anything to say about the way the land is run. He doesn't own anything. but a chance of getting profits if there is any. And that is, if any, our concern is with realities, not nomenclature. Appellate submits that ownership of the trust certificate is evident of his interest in the land, legal title to which the trustee holds. This view was definitely accepted by the Attorney General of Ohio in written opinions in number 3640 and in 3869. That is opinions of 1926, pages 375, 528, wherein he cites permanent declarations by the courts of Ohio and other states. See also 2 Cincinnati Law Revision, REV 255. Again, in brackets, Max claims that since he has some piece of paper and collects money on them, he must own something in the way of land, even though he admits that legally the fellows who run the land for him are supposed to own it. Some ex-Attorney General of Ohio once agreed with this idea in a general way and is applied to someone else. Accordingly, we must remember ascertain for ourselves upon what the tax was laid. The theory entertained by the Supreme Court concerning the nature of the appellate interest is not entirely clear. The following excerpts are from the headnotes of the opinion, which is in Ohio constitutional law of the case. Brackets. Even we, that is the Supreme Court of the United States, can't make much sense out of the legal language in which the Supreme Court of Ohio told what it thought Max Sr. owned. Try some of it yourself. Land trust certificates in the following trusts, that is the 7 described above, are mere evidence of existing rights to participate in the net rentals of the real estate being administered by the respective trusts. What Max owns is nothing by the right to collect some of the profits. Not so hard, was it, after some of the U.S. Supreme Court's own language. And that was in brackets. Ascribing to such certificates all possible virtues, the holder thereof is at best the owner of equity interest in real estate divided into shares, evidenced by transferable certificates. Section 5323, General Code, and it's in brackets here, 114, Ohio Laws, page 1715, does not provide for a tax against the equity interest in land, but does provide a tax against the income derived from such equity interest. Back to brackets here. Still, the Ohio Supreme Court talking, even if we were to admit that Max does own something in the way of land, Ohio isn't out to tax whatever it is that Max owns. Ohio is taxing the income Max made out of it. Okay? Apparently, no opinion of any court definitely accepts the theory now advances by appellates, but some writers to give it approval because it supposedly consonants with general legal principle. The conflicting views are elaborated in articles by Professor Scott and Dean Stone in 17 Columbia Law Review, brackets 1917, at pages 269 and 467. Back to the brackets. Back to the U.S. Supreme Court now. The state ideas that all Max owns is the right to get profits has never, so far as we know, been sanctified as the law by any court anywhere, perhaps because we couldn't understand what the Ohio Supreme Court said in the very case. We admit that mere lawyers and law teachers have played with the idea, including one of our own against a number, long before what he thought made any difference so far as the law was concerned. Note, 2, the reference to general legal principles. McGuire versus Trefry, that's spelled Trefry, 253 U.S. 12, much relied upon by appellates, does not support their position. There, the state of Massachusetts statutes undertook to tax incomes, the securities, that is personal, from which the income arose, were held in trust at Philadelphia. Income from security taxable directly to the trustee was not within the statute. The opinion accepted and followed the doctrines of Blackstone versus Miller, 108 U.S. 189, and Fidelity and Columbia Trust Company versus Louisville, 245 U.S. 54. Those cases were disapproved by Farmers Loan and Trust Company versus Minnesota, 280 U.S. 204. They are not in harmony with Safe Deposit and Trust Company versus Virginia, 280 U.S. 83, and views now accepted here in respect of double taxation. See Baldwin versus Missouri, 281 U.S. 586. Beller versus South Carolina Tax Commission, 282 U.S. 1 First National Bank versus Maine, 284 U.S. 312. The state of Ohio has tried to throw our own words back at us by reminding us of a case in which we once said that it was perfectly all right for a state to tax a man who lived in the state on profits that came to him through someone who was keeping property for him in another state. But that case was really quite different. One of the differences was that in that case, the tax was on income. And here, by pretty definite implications, the court seems to be saying for the only time in this whole opinion that the Ohio tax is not a tax on max income. Anyway, the controlling principles of that case don't control any longer. As we said in several cases since then, the principle that usually controls these days is that we see anything getting taxed twice is probably unconstitutional. In Brown versus Fletcher, 235 U.S. 589, 599, we have occasion to consider the claim that a beneficial interest in a trust estate amounts to a chosen action and is not interest in the RES, subject of the trust. Though Mr. Justice Lamar states, back to brackets, to get back to the real problem though, which is what does Matt Sr. own anyway? Somebody else once asked us to decide as a general principle whether a man who makes money out of property that is being kept and managed for him owns only the right to get money or whether he sorts of owns some of the property. This is what we're meeting the 9 lawyers who then made up the Supreme Court, most of them now being dead, that is, had to say. If the trust estate consists of land, it would not be claimed that a deed conveying 7/10 interest therein was a chose in action within the meaning of the Section 24 of the Judicial Code. If the funds had been invested in tangible personal property, there is, it pointed out in Bushnell case, that is Bushnell versus Kennedy, that is 9 Wall, 387, 393, nothing in Section 24 to prevent the holder by virtue of a bill of sale from suing for the recovery of the specific thing or damages for its wrongful caption of detention. And if the funds had been converted into cash, it was still so far property, in fact, instead of it in action, that the owner, so long as the money retained is earmarked, could recover it or the property into which it can be traced from there, having notice of the trust. In either case, in whatever its forms, trust property was held by the trustee, not in the opposition to Saskatchewan trust. So I see what he's saying now. So as to give him a chosen action, but in possession for his benefits in accordance with the terms of the testator will. Saskatchewan. If a man with some land that was being held for him by somebody else should transfer part of his estate in the land to a third person, no one would be fooled enough to claim that the piece of paper involved in transfer was chosen action. A chosen action being roughly a piece of paper that entitles its owner to certain rights, including usually the rights to collect money from someone. In that sense, the words chose to action are used in one section of the federal statute that tells the federal courts how various kinds of lawsuits should be handled. If instead of land, it had been goods or cash that was being held, and someone has swiped the goods or the cash, then the man with a stake in them could bring a lawsuit to get the stuff back. At any rate, whoever might have been holding the property for whoever had a stake in them, it would in truth have been holding the property for whoever had a stake in it. And just try to figure out what any of this, whatever it means, has to do with Max Sr. and the tax he doesn't want to pay. The beneficiary here has an interest in and to the property that was more than a bare right and much more than a chose in action. For he had admitted and recognized fixed right to the present enjoyment of the estate, with a right to corpus itself when he reached the age of 55. His estate to the property thus in the possession of trustee for his benefit through defeasible was alienable to the same extent as though in his own possession and passed it by deed. Ham versus Van Orden, Orden, 84, New York 257, 27, Stringer, Stringer versus Young, trustee 191 New York .157, 83 NE 690 Lawrence versus Bayard, Bayard, 7 Page, in brackets, New York, 70. Woodward versus Woodward, 16 NJ, EQ.83, 84. The instrument by virtue of which that alienation was evidence, whether called a deed, a bill of sale, or assignment, was not in a chose in action payable to the assignee, but as evidence of the assignee's right, that is, title and estate into the property. Now back in brackets. The man who was having some property held for him, in this case, namely the case that had been decided 15 to 20 years before, owned something more than a chose in action. This fellow, as a matter of fact, had the right to any profits from the property that was being held for him, and also the right to take over the property into his own hands when he reached a respectable age. He also had a perfect right to sell his rights, and apparently he had done just that. The paper that he represented the sale of these rights was not a chosen action. It was proof that the man who bought the rights now had certain rights in the property in question. The doctrine of Brown versus Fletcher is adequately supported by courts and writers. The Narrow-Janski's Mutual Fire Insurance Company versus Burham, that is 51 RI 371, 154 ATL, 909, Bates versus Decree of Judge of Probate 131 ME 176, 160 ATL .22, Bogart, BOGERT, Handbook of the Laws of Trust, 430, semicolon, 3 Prominent Equity Jurisdiction, 4th edition, 1928, section 975, pages 21, 17, 2117, semicolon, 17 Columbia Law Review, 269, 289. We find no reason for departing from this action. Judges and others have from time to time agreed with the general principles just quoted. So do we. The challenge judgment must be reversed. Therefore, Max Sr., remember him, doesn't have to pay his tax. And that, ladies and gentlemen, is the opinion of the Supreme Court in the United States in the case of Senior versus Braden. In order to find out what the Supreme Court was talking about, and also what it wasn't bothering to talk about, the case of Senior versus Braden, it's necessary to go back a little into the general principles of constitutional law that presumably control the decision. They start in the 14th Amendment, despite the fact that the 14th Amendment played very little part in the court decisions, opinions to say, and of course they start in the due process clause, you see. The primary, remember, this is all under Oliver Wendell Holmes' perspective now. This is already happening, changing in all law becoming legalese, you see. The primary principle involved is to get the effect that when a state tries to tax something which it has no jurisdiction to tax, that amounts to attempt to deprive somebody of property without due process of law. Inasmuch as jurisdiction means loosely power, such a rule seems not too unreasonable. At least it seems not too unreasonable once you have swallowed the court's habit of using the 14th Amendment for other purposes in the protection of Negroes and others against unfair criminal trials. But obviously, see, they've opened the whole thing wide open. It wasn't meant for that, you see. But obviously, that leaves it entirely up to the Supreme Court to decide what a state has power or jurisdiction to tax and what it hasn't power or jurisdiction to tax. In the course of deciding, the court has laid down a lot of sub-principles which give jurisdiction that is a special and sometimes indefinite meaning. The first sub-principle is that a state has no jurisdiction to tax land outside its borders, and that regardless of what relation it has or hasn't to the 14th Amendment. Seemingly eminently sensible and fair. It also seems eminently pointless for New Hampshire, for instance, would no more try to slap a property tax on a farm in Iowa than the United States would try to tax a ranch in Argentina. Correct. There wouldn't be any way of collecting a tax, and no state would be idiotic enough to try. But starting from that fair, its pointless principle, the court has gradually built up other principles about what a state has or hasn't jurisdiction to tax. A lot of property today, like stocks and bonds and IOUs and mortgages and trust certificates, is not so solid and stationary as land. And so, occasionally, differently. Different states try to tax that kind of property at the same time, and the owners of the property don't like it. So the Supreme Court had an obligation that is enshrined in the law of various complicated sub-principles telling which states have jurisdiction to tax that kind of property and which haven't. And these jurisdictions rules have been carried over with refinements and exceptions to other kinds of taxes than property taxes, especially to inherited taxes. Where inherited taxes are concerned, the court has laid down the principle that if two states try to tax the transfer of the same property at the death of its owner, then invariably one of the states has no jurisdiction to tax that transfer, even though the owner may have lived in one state and kept the property in another. This is what the Supreme Court was talking about in Senior versus Brayton when it mentioned views now accepted here in respect of double taxation, and namely several cases. All the cases named dealt either with inheritance tax or else with the application of various sub-principles of the jurisdiction rule to property taxes on other kinds of property than land. The state of Ohio, not unnaturally, had assumed that all these cases had very little to do with the problem in Senior versus Brayton. The state of Ohio thought it was arguing about an income tax since the tax it was trying to collect from Max Senior was computed by taking 5% of part of his income. And the Supreme Court had never been before stretched any of its jurisdictions rules so far as to stop a state from taxing the income of someone who lived in the state. That is why the state of Ohio thought the case of McGuire versus Trefferly, which allowed an income tax very much like the tax on Max Senior, was even though older, more to the point than all the inheritance tax and property tax cases the court named. The court, however, seemed to say that the principles of McGuire versus Trefferly were no longer controlling because the inheritance tax and property tax cases decided since then had made other principles more important, even for income taxes. But as a matter of fact, the court seemed to forget what it had decided in an even more recent case called Lawrence versus State Tax Commission, although the Lawrence case was actually mentioned in the opinion in another connection. Where in Lawrence versus State Tax Commission, which dealt with income tax, the principle of McGuire versus Trefferly had been followed as perfectly good law. In short, the court had held, even after laying down the principles that limited state jurisdictions to tax in the inheritance tax and property tax cases named, that it was quite all right and no violation of the 14th Amendment, or as a state to tax the income of someone who lived in the state. So in order to make any sense of all of Senior versus Brayton, the Supreme Court must have been saying that the tax on Max Senior wasn't an income tax, but a property tax. And indeed, the court implied as much as the opinion has said so, definitely since. Now, as everybody knows, a property tax is universally considered to be a tax measured by the value of the property and collected every year, whether the owner makes profit out of the property or not. The tax on Max Senior was measured by his profits, and there hasn't been any profits, there wouldn't have been any tax. But that little practical matter didn't stop the Supreme Court from calling it a property tax anyway. The court excuse presumably was, and in brackets, and notice how often you have to guess what the court means just to make its decision fit in its own principle of law. That is, that the Ohio legislation, in writing the tax statute, had inadvertently labeled it as a property tax, even though it was measured by income. The fact that the Ohio Supreme Court had ignored this slip and treated the tax as what, practically speaking, it was, didn't faze the U.S. Supreme Court. Nor did the fact that it is strictly the business of the Ohio courts and no concern at all with any federal courts to interpret the statute of Ohio. Correct. Completely correct. For the U.S. Supreme Court blatantly treated the tax as a property tax. Meanwhile, proclaiming, you may remember, our concern is with realities and not nomenclature. In constitutional law, a rose by any other name does not always smell so sweet. Even granting then with a gulp, that is, was a property tax that Max Senior didn't want to pay. Why had Ohio no jurisdiction to collect it? One of the cardinal sub-principles of the jurisdiction rule is that a state has jurisdiction to put a property tax on property owned by someone who lives in the state, if that property, instead of being lands or goods consisting of pieces of paper such as stocks or bonds which give the owner certain rights. And surely what Max Senior owned was a few pieces of paper called trust certificates that entitled him to some of the profits from 7 plots of land on which he had no right at all to go build a fence or a house. There is at least no doubt that if Max had bought, instead of just trust certificates, shares of stocks in a corporation that managed plots of land, just as the trustee managed the plots Max had a stake in, then the state of Ohio could have taxed those shares or stocks without the Supreme Court raising a finger to step in, or stop it, I should say. What difference? The difference, and the only difference, is the legal wording of the pieces of paper that did give or might have given Max a right to share in the profits. If he had held the shares of stocks, he would have been nothing but a stockholder. But since he held trust certificates, he was in legal language a Sesquibu trust. And being a Sesquibu trust, which only means someone who trusts someone else to hold property for him, you see. Max Sr. claimed he was, in a sense, the owner of some of the land that was being held for him. He claimed he was the owner of land despite the fact that he had no right or whatsoever to build a fence on the land or to manage it, but only to collect some of the profits. If it was land that Max owned, some of that land being outside of Ohio, and if that tax the state was trying to collect was a property tax, then, argued Max, Ohio has no jurisdiction to collect the tax. Or by the very first sub-principle of the jurisdiction rule, a state has no jurisdiction to tax land outside its borders. And so, at long last, appears the question to which the Supreme Court devoted almost entire opinion in Senior versus Braden, taking the problems and principles discussed, thus far, almost entirely for granted. The question was this: does Max own land, or does he merely own the right, written on some piece of paper, to get some of the profits from certain plots of land that are being held by somebody else? In seeking the answer to this question, the court, despite its vaunted concern for realities, paid no attention whatsoever to the practical setup of the business arrangement under which Max Sr. had collected $2,000 in 1 year. Instead, the court looked back to an old Supreme Court case of almost 20 years before in order to find a general principle. The case was Brown versus Fletcher. Yet it happens that the problem presented and solved in Brown versus Fletcher had not the remotest relation to the 14th Amendment, to taxes on land, or to taxes on anything else. It's like pulling a rabbit out of a hat here, folks. The problem of Brown versus Fletcher was purely a problem of the proper legal procedure in the federal courts under the federal statute governing such procedures. The statute denied the principles of bringing suit in the federal courts to certain signees of chosen in action, or people to whom had been transferred pieces of paper entitling their owners to certain rights. The central character of Brown versus Fletcher claimed that a piece of paper that had been transferred to him was not chosen in action, and that he was privileged to sue in the federal courts. This piece of paper, incidentally, there was something like Max Sr. trust certificate in his legal language, gave him many more rights than Max Sr. ever got from the trust certificates. The Supreme Court agreed that the paper was not a chose in action, and that its owner was entitled to bring suit in the federal courts. And this was all to do with Brown versus Fletcher amounted to. In the course of deciding this, the Supreme Court wrote the two long, rather incomprehensible paragraphs that were quoted verbatim in the Senior versus Braden opinion. And it was on the basis of these two paragraphs expressing a relevant general principle that the Supreme Court of a generation later concluded that Max Sr. did, in a sense, own land, and so could not be taxed by the state of Ohio. Thus, the reasoning of the court in Senior versus Braden boils down to something like this: the 9 judges who held our jobs almost 20 years ago in deciding a problem of federal court procedure expressed the general principle that certain pieces of paper giving their owner certain rights were not technically chosen in action. Therefore, what Max Sr., whose trust certificates read something like, these pieces of paper really owns his land. Some of that land is outside of Ohio. Ohio is trying to tax some of the profits Max Sr. made out of his stake in that land. The tax, even though it is measured by the profits so that it works like an income tax, is called property tax in the statute. Therefore, it is a property tax. Since it is a property tax, it is a tax on what Max Sr. owns. But what Max Sr. really owns is land, some of it outside of Ohio. Therefore, Ohio is trying to tax land outside of Ohio. Can't do that, folks. But we have a principle that no state has jurisdiction to tax land outside its own borders. Correct. We also have a principle that a state tax is something which the state has no jurisdiction to tax, deprives the taxpayer of his property without due process of law, and so violates the 14th Amendment. Therefore, Ohio attempts to collect a tax from Max Sr. is forbidden by the Constitution. Therefore, Max can keep his $100-odd. nor can you hold on just a little longer, is that all there is to Senior versus Braden, although it is all that can be explained even by the circular, irrelevant abstractions of legal logic. Max was allowed to keep every cent of the $100-odd that Ohio was trying to take from him in taxes. Yet part of the land that Max had stake in was not outside Ohio at all. It was inside Ohio. So even if it was a property tax, and even if what Max owned was really land, why couldn't Ohio tax the land inside its own borders? What was unconstitutional about that? There isn't even a legal answer, folks. The Supreme Court jurisdiction principles under the 14th Amendment allowed, as they would obviously have, to allow a state to tax its own land. True, the Ohio land that Max had a stake in had already been taxed once that year on their regular property tax. So considering the tax in the case of the property tax, that makes two property taxes on the same land. But there's nothing in the Constitution that forbids the state to do that if it wants to. There is not even a Supreme Court principle that forbids it. The court ruled against double taxation, implying only the taxation of the same thing by two states. The Ohio Constitution might well have forbidden it, but the job of saying what the Ohio Constitution forbids or doesn't forbid in legal tradition is exclusively the job of the Ohio courts. Correct. The Supreme Court has no business in this. And the Supreme Court of Ohio has said that, so far as it was concerned, the tax of Max Sr. was entirely constitutional. Of course, there was that double dare of state lawyers in the case to the effect that the Supreme Court was crazy enough to call the tax a tax on land, then the court might just as reasonably throw out the whole tax. Apparently, what the court did was simply to take the dare, despite the fact that there was not so much as a shadow, even a legal excuse for throwing out that part of the tax that applied to Ohio land. Thus, not only the inaccurate interpretation of a phrase of the Constitution or the invoking of a vague general principle about jurisdiction or the dependence on tax nomenclature in the face of a contradictory reality or the muddied language of a case about something entirely apart from the issue that was decided many years ago. Not only of these, but even the foolish bravado of a lawyer can serve as a foundation on which the Supreme Court may build a chunk of constitutional law. Here in miniature is the whole vast structure of sacred abracadabra that makes up the highest law of the land, and any non-lawyer with half a brain in his head, if only he could penetrate the smokescreen of legal language, would have recognized the alleged logic, not only of Senior versus Braden, but of almost any Supreme Court case you could name as nothing more, nothing less than an intellectual fraud. The fraud may have been more obvious in Senior versus Braden than in most, simply because the manipulation of legal limbo, as logic was more inept and clumsier than usual. But even when the non-master jugglers are working sorry about that, are working on their smoothest, it requires only a trained eye to see that these weighty thoughts they seem to be tossing around are in reality no more than balloons, full of hot air and easily punctured, I should say. And the worst of it is that the Supreme Court, like all courts and all lawyers, is all the time dealing with and settling practical problems. There was a very real problem in state finances involved in Senior versus Braden. By virtue of the court's decision, Ohio lost in revenue not only Max Senior's $100-odd, but the thousands upon thousands of dollars it would otherwise have collected as taxes from other Ohioans who had been making money the same way Max had been making money. Should Ohio then look to another kind of tax to make up the lost revenue, you see? Or should it amend the old statute, called the tax income tax, this time in hope that the Supreme Court 3 or 4 years later, when a case gets that far, will be impressed by the label and hold the statute new constitutional. Regardless of the right answer, the court's solemn consideration of the type of property Max Sr. owned or didn't own seems scarcely pertinent to a solution of Ohio or Max Sr. fiscal difficulties, even if the court has snapped that Ohio was taxing legitimate investments too heavily and ought to cut down on its spending anyway, and that therefore the tax under dispute might not be collected. Such a decision, though hardly judicially in matter, would at least have made a great deal more common sense than any discussion of choses in action and interest in land and similar irrelevant ambiguous abstractions. Furthermore, the largest question with the court has been gaudily disposing of in the name of the 14th Amendment under its general principles about state jurisdiction to tax involves a extremely practical problem too, from the angle of the state governments. The problem is simple. Now that the people and companies and properties we have to collect taxes from in order to keep running are spreading themselves over a dozen of 48 states, or most of them are today. How are we supposed to keep up with them? And what kind of taxes can we impose on them without either chasing them out of our reach entirely or else going to so easy on them that we don't collect enough money to keep going? From the angle of the taxpayers, whether people or companies, the problem is simple. Just because our business or our property spreads over a lot of states, is it fair or right that every one of those states, or most of them, should soak us with the same kind of taxes so that we have to pay tribute a dozen times for doing or owning one thing, whether it's income taxes, property taxes, or inheritance taxes that are involved? The basic premise of the problem is the same. Towards the efficiency solution of that problem, the Supreme Court jurisdiction principles contributed literally nothing. A categorical statement that the 14th Amendment denies to any state but the state of domicile. What is domicile? Who is she these days? The jurisdiction to impose an inheritance tax on the transfer of intangible property. Brackets, when in intangible property, not intangible, as with Max Senior trust certificates. May sound very learned, doesn't it? Has made the rule that acquisition of a business site within a state by intangible gives even a non-domicilial state jurisdiction to tax. But neither the formation nor the application of such principles and their sub-principles and the exception sheds even the dimmest light on the basic governance of the state government and the taxpayers. The fact is that the Supreme Court had neither the power, correct, nor the ability to find for the problem in government here involved. It had no business in this court, folks. This is crazy. A thorough or intelligent or workable solution, which fact does not bother the court in the slightest difference. Agree. It just goes merely laying down and applying silly little abstract rules about jurisdiction to tax, and giving each of those silly little rules as much potency and prestige as it has been adopted by the people as an amendment to the Constitution. As in Senior versus Brayton, so in all the jurisdictions to tax cases, the meat of the real problem is passed by the law sinks in teeth into the fluff of abstract logic. As in the jurisdiction of tax cases, so as in all the cases under the Due Process Clause of the 14th Amendment, as in the cases under the Due Process Clause of the 14th Amendment, so in all constitutional law, as in constitutional law, so as in lesser branches of legal learning, so in the whole of the law, and only in the solemn and mysterious mumbo-jumbo of legal language keeps the non-lawyers from catching on. For instance, the citizens who directly and indirectly voted the 14th Amendment into the Constitution to protect the rights of Negroes just after the Civil Rights War might be a little surprised to learn that under the law that had forbidden the state of Ohio to collect a tax of $100 from Max Senior. So I'm going to give you my spiel on this. The 14th Amendment, and I have a book on this, it was never ratified. It was never ratified by the states. Neither was the 16th. I have books on that. And unfortunately, when this happened just after the Civil War and all the things that took place during that Civil War afterwards was the complete, again, taking away people's rights they were doing, you see. And they had no business in this one because it's a state issue. It's not their business. Why would it be in the federal court? Why? Makes no sense. And then what it seems to be is they're setting a case law that will be used later on in that situation. That's what they're doing. They're setting a precedence of doing that. So the next time the guy comes in, he won't have any choice. He'll have to pay it or whatever, okay, or the other way around. But again, this is a state issue. It has nothing to do with the federal government. What the hell are you doing? But this is the type of court that actually overstretches itself and gets involved in all kinds of things that it has no business being involved in, you see. So that's just my take of this. This is, again, by Fred Rodell. He was a professor in law at Yale University. And I would assume it's probably Yale Law School is what I'm thinking of. But the point is this is overstretching of the federal court. And it's this over and over. This is where it starts. This is where it begins at, folks. This is where it starts to it gradually gets in places where it has no business in. And this is how tyranny takes place. This is how it takes place. This is how tyranny takes place. And if you read some of the Red Rodale, which I'm to the point, this is also a time, in this period of time, where we see that this is a time when Franklin Delano Roosevelt is also, not only have an active court here involved in this issue, we also have Franklin Roosevelt trying to stack the court. He's heavily involved in what we call progressive ideas. And this is over 100 years ago, and manufactured this whole idea of what he wanted to push on the people. In fact, Roosevelt wanted a socialist form of government, and Roosevelt was not what we call a good man. He's in the same league with Woodrow Wilson, who was a former president. When I listen to what Fred Rodale is trying to explain here, I'm not going to go too much longer, is that they frankly didn't have they didn't have any business involved in wasting people's time themselves, everything. But they chose to do this in order to set precedents for the future. That's what they did. They were what I call a court that didn't rule on what was going on, that was legitimate cases, but they were overstretching their arms. They were getting more power from this. This is what they did. And this is the whole deal with Oliver Wendell Holmes, who in the early 1900s, that is 1919, I think is right, 20. This is what's taking place. They're getting involved in stuff they had no business in. Let the state of Ohio deal with it. Even though Mr. I think his name was Stan, I think it was, had all these things in his way of dealing with. In other words, he was benefited, I should say senior, benefited from this. But in reality, it was never the court's business. Federal court and state court are separate, period, unless it deals with a federal law, not with a state law. Difference. That's why you have 50 states. If we're not going to do this, we don't have any business calling any of these states states. It would be just one big piece of property that's the United States of America. You follow? So this is a destructive way of being involved. And it's also what they do is they do something else, which I've shared with what Fred Rodale is saying, is simply they're overstretching and not seeing what they're really saying in this act. In other words, what they're presupposing this is what it's saying, when in reality, it's not what they're saying. It's not what was in that court. You see, their presuppositions are here. They're not coming in here with an open mind at all. The Supreme Court isn't. Not only are they having business not being in the state's business, they're now presupposing that this is what this 14th Amendment means. And in reality, simply is, it may be that or may not, but it's not definite. And so this is what takes place, you see. And so they've overstretched their bounds here. That's what people don't understand here. And I know it seems complicated, but it's not. It's just a way of the state losing its powers and the federal gradually getting more. And yes, he benefited. And if this case comes up again, you know, whatever the such and such thing comes up with Mr. Senior, then what's going to happen? They're going to go back to this because this is what they call case law. So case law means simply they present us what was before it. And they'll say, oh, this is what we decided in 1929 or whatever year, 39 or whatever. And this is what it says. They will not go back before then. That's the difference. That's the critical difference of case law. Case law, what it does is simply is it doesn't go back to the beginning. It's building a case in order for them to have, in a way, taking more and more power, or whatever you want to call it. They're getting more involved in people's pocketbook or their land or whatever they can do and what they can't do. That's what case law does. You can go back, because I've taken some courses in college and simply constitutional law and all this, and it's just like, I remember going to the law school and I'm saying, why do I read all these case laws? You see, they made a mountain out of a molehill, folks, here. If you're going to follow the Constitution, let's look at that. But what they've done is created all this mumbo jumbo stuff to the point that basically it doesn't do the people any good. They could just choose whatever they want it to mean. And that's what's fucking scary, you see. So I appreciate you being here tonight. Thank you for attending. Hope this is clearing up some evidence. Fred Rodell is probably unfortunately, it's almost impossible to get his book because you know why? Because he hits to the point very straight, very clearly, and unfortunately, there's not many people who teach law in the way he did. In fact, he's probably one of the last people. I think he sensed that. That's why he wrote this book. And he wanted to share what he was seeing and kind of put up a firewall and saying, this is wrong. This is wrong. What are you doing? You can't do that. What does the federal government have to do with anything with the state? But this is how the federal government gets more and more involved. This is why, for example, I'll just say this very clearly. I know this court case, not a court case, but an argument with the governor here in South Carolina, probably 20 years ago. The state wanted to have its own deal, what they want to do in school curriculum. And that was like, we're not going to follow these things. And that was what was said for about a week or two. And then the federal government comes along and says, that's okay. You don't have to take that. You don't have to believe that. We just won't give you any money for your schools. Because, see, the states are dependent upon that federal money. You see, the states collect the taxes from property or whatever. They're the middleman, so to speak, and then that money goes to the federal government. We would say the IRS, whatever you want to call it. So the state is doing the dirty work, you see, and the federal government rewards that. And then what they come back with, well, okay, we've got 100% of your money, and what we're going to do is give you 25% back. And so that's what they do. And so the states have become what I call at the trough as a pig, have gotten used to that. And they just basically say, we just want the money. So they won't stand on any type of foundation or whatever's right or wrong. They just simply, say a bunch of barks, and then about 2 or 3 weeks later, the tail between their knees, between their legs, no, we want the money, you see, and they'll give in. They won't stand for anything. So they know simply that here in the state of South Carolina, well, that's not going to work, you see. Or, we don't have enough money for buses or building this and that. The funny thing is simply with the building of the schools is that's a bond issue at the county level. It's not actually at the federal or state level. So the state, not the state, but the county does that in order to build a building. So they produce bonds. So what happens simply is those bonds, they don't have any money, folks, or they claim they don't, but they do. They do. And so what happens, in fact, one day we're going to talk about what I call a big issue, what they call comprehensive annual financial reports, which is state that simply they've got more money than me and you would ever have, you see. But again, I'm getting a little long time here, but I just want to explain these things to you. All right, you have a good night. You take care, and thank you for your listening. Thank you for listening to this video. And again, Discerning What Is True is my channel on Honesty and also on YouTube. Thank you. Have a good night.